As an artist or a music tech startup using AI, it is very likely you have dealt with copyright law issues at some point. I now have the honor to introduce Sophie Goossens, an expert on copyright law, digital media, and technology, who will present the next keynote at this AI and Creation Day, titled AI, Creativity, and Music, Legal Update. Sophie Goossens' education made her acquainted with common and civil law systems of copyright. She obtained a master's degree in private and corporate law at the Université Paris 2 Panthéon-Assas and another master's degree in intellectual property and new technologies at the Faculté Jean Monnet of the Université Paris-Saclay, where she also wrote her thesis on copyright law for podcasting. She then worked as an attorney and legal consultant for several music labels such as Green United Music, law firms in the entertainment sector, and Getty Images in Paris and London. Furthermore, she served as a board member of the Music Managers Forum UK and taught European IP law at the Université Paris Sud for 2 years as a guest lecturer. Since 2017, she has been working as a counsel for Reed Smith and became a partner there last year. At Reed Smith, she is advising large international clients, but also startups at the interface of media and technology on legal, but also on policymaking and commercial matters. Her expertise and interest in innovation and AI technology make her the perfect speaker to give us an insight into the latest legal developments concerning AI and creativity. Please welcome Sophie Goossens.
Thank you very much, Rebecca. Hi, everyone. It's a pleasure to be here. It's a pleasure to be participating to this edition of Wallifornia for the second year in a row. I want to start by thanking everyone in the team for inviting me. And I don't think there's anything else I should say about myself. Rebecca did a really great job at introducing me. Perhaps just to say that, of course, a lot of the work that we do at Reed Smith focuses on the entertainment and media industries, and I think my practice has a particular focus on technology and anything to do with how the entertainment business is being reshaped by the use of technology. So AI is definitely a key area of focus for me, and that's why I have been invited today to give you a bit of an update on what's happening in relation to AI and copyright. So I think I have something like 30 minutes to try to give you an update, and then we will have 10 minutes or so for questions. So I will get started. I will start by just setting the stage and talk a little bit about some of the examples that exist out there in relation to creative AI. I'm sure that all of you are going to be familiar with the Flow Machines project, which is now a few years old, which was the project headed in its time by François Pachet when he was working for Sony CSL. And that was this new Beatles song that was generated using an AI that had been trained on the entire catalogue of the Beatles. On the right on the slide, you see a painting, which is the portrait of Edmond Bellamy, which was the first painting to be auctioned, I believe, at Christie's, which had entirely been realized by an AI. On the left, you have another project called the New Rembrandt. That was a new painting, at least a painting in the style of Rembrandt, which has been also generated by an AI that had been trained with all the paintings of Rembrandt, etc., etc. You also have examples in relation to physical individuals like Elton John, and a ton of examples right now in the video game sector that is generated video game environment using AI. So these examples illustrate really well how this idea of machines being able to create things that look like a work of art and look like a content that might be protected by copyright. Why this is now really topical and why it becomes really important for a lot of legislators and stakeholders in many different countries to try and understand how this is going to fit in the legal landscape. So a lot of challenges to copyright laws. There is, of course, the question, the central question, which is whether a human is required for copyright to exist. The other question, which we are going to be spending a few minutes on, is the question regarding the training set. When you train an AI with millions of recordings and songs, is that an act which requires the permission of the rights holders? So in other words, if you do not have permission, could that constitute an infringement to copyright? And then there's the more general question about the balance, how to balance the value of human creation and AI creation. Basically, what values should be assigned to AI creation in our society? As we can see, AI is also really gaining traction in the political agenda. There's been a number of reports written recently about AI and creativity and copyright. There's a report in France, there's a report in the UK, which has just been published. There's, of course, the white paper from the European Commission and other texts that are being published by the European Commission as we speak. And then just before we start talking about the real issues about copyright, I thought it would be just interesting to frame a little bit the conversation. So in legal terms, we consider that AI is made of 3 steps. You have on the one end, anything to do with the inbound, which is the training stage. All the data that is being analyzed and mined by the AI, that's going to be one source of legal questions. In the middle, you have the algorithm, which is the AI itself, which is also protected by IP and also protected by copyright. And then you have the third, excuse me, which is the outbound. And the question that is relevant on the outbound is whether the creation that has been generated by the machine is likely to be protected by copyright or not. So during the rest of the presentation, I'm going to focus mainly on step 1 and 3, just because it looks like at the moment, those are the steps that are really challenging copyright law as we know it. Step number 2, which is all the rights that are generated by the software, the algorithm, this is not new. There is no real difference to the law, whether you consider a regular software or a software capable of artificial intelligence. So we'll keep that for maybe another day. We'll very much be focusing on the inbound and then after on the outbound. So let's look at the input. That's training AI with data that is copyright protected. So the act of training the software, also known as text and data mining, also known as machine reading, is in a nutshell the act of analyzing a large set of data by a machine. It's the same way that we humans learn. But when we read books or when we watch movies or listen to music, we do not need to ask a special permission from the rights holders. This is not something that is restricted by copyright. machines are different. And the reason why machines are different is because they need, in order to read a set of data, they need first and foremost to make a copy of it. And this act of copying, which is also part of the normalization process of data, is an act that is restricted by copyright. So when we have said that, the next step for any lawyer working in the copyright sector will be to look for whether an exception exists or not. That could be helpful in this case, especially if we work with a tech company which is doing AI and which is looking at using a large set of copyright protected data to train the AI. So there is a copy that exists in copyright law, which is called the temporary copy, which was invented to cover acts of reproduction that are ancillary to a technological process. There are a few conditions that need to be met in order for that exception to apply. One of the conditions is that the copy needs to be, as it says, temporary, so it cannot be a permanent copy. Another condition is that the copy should not have any economic value in itself. So what we, having spoken with a lot of developers, what we see is that this temporary copy exception to copyright is not a great fit in the AI industry. One of the reasons why it is not a great fit is because we see that it is quite useful to keep a copy of the training set, not only if you need to retrain with the same training set, but there's also a possibility that you will need to keep a copy of the training set in order to comply with the new obligations that are being created and that are starting to be shaped by the European Commission, one of them being the traceability. And this idea of traceability is the idea that you can retrace your steps and that you can go back in time and try to look under the bonnet of an AI system to try and understand why the outcome is what it is. An example of the traceability obligation is in relation to face recognition, for example, where sometimes when a bias is discovered, it's important to go back to the training set to try and identify why the bias exists. Like the same could be true for data and AI systems that have been trained using music. So we see that the regulation is evolving in a direction that is probably soon going to impose that training sets are being recorded so that they can be also audited. And of course, that is directly in conflict with this temporary copy exception. So we see it's not a great fit. There's another situation. Oh, that slide is empty. It should be full. Luckily, I think I remember what was on it. So this slide was initially supposed to illustrate the geopolitics of AI. You have different viewpoints regarding copyright and AI, depending on where you are in the world. And the viewpoints regard the act of text and data mining. Is that something restricted by copyright, yes or no? So if we take the position in the US, there is at the moment, a view which seems to be accepted by a majority of lawyers. To the best of my knowledge, it's not being challenged in court. It has not been confirmed by like a specific decision on AI. But however, there is a majority of lawyers and academics which tend to agree that the act of text and data mining would be covered by fair use. That means that no copyright permission is required in order to process with text and data mining operation on a training set covered by copyright. If you go then to Asia, in certain countries in Asia that are very much in the race for AI, including Japan or Singapore, you will, if you open the copyright textbook, you will see that there are exceptions to copyright covering the same thing, which is text and data mining. And the exceptions have been made and have been drafted in order to avoid any the need for permission. So it basically is meant to give a lot of flexibility to the tech industry and to make sure that they will not be hindered or hampered in their development by the need for licensing. In Europe, we have a different situation. We have different views that have been expressed during the adoption of the Copyright Directive. So the Copyright Directive was first tabled in 2016, and then it was adopted in 2019, and now it is in the process of being transposed in the member states because the deadline for transposition has now passed. It was on the 7th of June. Let me see if the next slide is a bit better. Yes, it is. So if we look at the copyright text, two articles are really important for us. One is Article 3, the second is Article 4, and those two articles, 3 and 4, they deal with an exception to copyright for text and data mining. So initially in 2016, when the text was first published, the exception was already in there, but it was only to the benefit of research organizations and the scientific community. What that meant is that in 2016, the text had not planned and did not contain anything that could benefit the private sector and commercial entities. There was some lobbying that happened, and at the very last minute, we saw a new provision added to the text with an exception that would benefit everyone. So that became Article 4. However, by way of a compromise, in order to satisfy the rights holders, which were really unhappy with this new exception, a caveat was introduced. And that caveat is the possibility for copyright holders to opt out of that second exception. So the result is you have one exception, Article 3, which applies for research organizations and the scientific community without the possibility to opt out. And then you have an exception that applies to everyone else, including the private sector, with a possibility to opt out. This opt-out exception is something really new in the copyright landscape, something that has not really, we don't really have any precedent for it. So it will be interesting to see how it applies in practice. It will be interesting to see how it is being transposed. A few of the issues that we already foresee will be in relation to the burden of proof. Normally, it is the person benefiting from a copyright exception which is supposed to demonstrate that they meet the condition and the criteria for the exception to apply. Here, it will be difficult, and it appears to be difficult, to demonstrate a negative fact. It seems like it could be really difficult for a company which is doing text and data mining to demonstrate not that the rights holder whose data is being mined did not opt out. So it will be interesting both for us lawyers, but especially for everyone in the tech community to also keep an eye on how this is transposed in the legislation of every member state in the EU, because it could cause some headaches for all of the companies that are using data sets online or trying to mine data that is being accessed online outside of a license agreement. So this is just a copy and paste of the text of the directive. You have here the Article 4 and the Article 4.3 is where you have these opt-out that is provided. As you can see, there is a little light in this potentially uncomfortable provision for the tech providers. And this is in the last part of that sentence when it says that the reservation has to be done in an appropriate manner, such as machine readable means in the case of content made available online. So this is potentially something that may be used by, again, tech companies and to to decide to get information about whether or not a rights holder has opted out. And it may be that if you do not use machine readable means, then the opt-out could be deemed as not valid. So hopefully we will end up in a situation where the decision to opt in or opt out will have to be made in a way that is readable by a machine, so that there is no, at least there is a method out there that is available and that is relatively practical. Here again, an empty slide. This is a slide where normally you should see some of the other challenges that we see in relation to this exception. One of the challenge, of course, is that if the rights holder has opted out, then you end up in a situation where you need a license, because mining, at least making copies for the purpose of text and data mining, would not be allowed unless you are a research organization or a member of the scientific community working in the public space with public money. And we all know, especially in the music industry, that the number of rights holders can be extremely important, that only one song and one recording can sometimes have over 10, if not 20 different rights holders. So of course, if you're going to train with millions of songs and millions of recordings, it becomes quite a daunting task to imagine that you would need to clear one by one each of these different contributions. Another consequence of this text is that it is very likely that we will see more and more data sets being offered for license. There already exist a number of websites where you can go and find data sets that are available and that come with a license. It looks like a number of rights holders are currently working on packaging offerings for the tech community in order to give a solution and to give access to data, but within the context of a license agreement and within the control that the license agreement can give them. So that's an evolution that we, of course, will keep an eye on, and we invite you to keep an eye on as well. I have a few minutes left to talk about the second part of the presentation, which is what are the copyright implications and the copyright questions arising on the other end of the machine, not in the training stage, but in the stage where the machine has been trained and is actually working, and when the machine is generating creations. At this stage, other copyright questions are relevant. And those are mainly whether what is being generated by a machine can receive the protection afforded by copyright or not. And of course, that's a critical thing to know if you are working in this space, because although it's not because the response would be no that you lose every protection available, you have plan Bs and plan Cs if copyright protection is not an option. But of course, copyright protection is extremely solid, strong, robust, and reliable type of protection. So knowing the answer to the question as to whether or not AI-generated works might be protected is probably going to be key for a lot of business models and businesses out there. So if we take a look at what is exactly a work in copyright terms, we see that there are a few key things that are needed in order for the law to recognize the existence of a work in copyright terms. First, you need an expression, and that could be any type of production in the literary, scientific, and artistic domain. I think that we can argue that there is an expression, there is a production, so the machine is generating something, so that is not a problem. Second thing is you need an author. And we see here that, by the way, everything that is included on this slide has been extracted from copyright treaties and texts with an international scope and reach. So this is not country specific. We really tried to take a look at this on the basis of the texts that apply internationally. So the author, the definition I took here is from the Berne Convention, which is one of the oldest treaty on copyright that still exists and that still is in force. So we see that this text, but all the other texts after it, make a strong reference to authors, to their successors. We also see that the duration of protection of copyright is based on someone's life and the duration of someone's life. So as of today, it is quite difficult to imagine that the law, as it is written today, could welcome the creation of a non-human, of a non-author. The absence of an author would probably mean that there is an absence of a work as it is defined by law today. Finally, you also need originality. The originality is also defined in relation to the author. So there's another reason why you would need an author in order to have a work. And I've included here the definition, one of the definition of originality that has been given by the Court of Justice of the EU. As you can see, it's the author's own intellectual creation. So the connection is quite clear. To conclude, we can see that the international and European copyright laws seem, at the moment, relatively unable to accept the notion of a work created without a human creator. Another question that comes, that is often asked is whether you can use AI as a tool as opposed to using AI to self-generate creation from A to Z. So here we have an example where AI, the creation is AI assisted and not just AI generated. So here we have a bit more consensus from the legal community. There seemed to be a general consensus in every country, at least all the countries that are currently looking at AI and copyright, that when you use AI as a tool, you do not run into the same type of problem. It continues to be a tool yielded by a human, so the human will be considered the creator, and there is no real issue in accepting that. Another challenge comes to the fore when human input becomes really limited. If the input is extremely limited, it's just like a yes or no action or just pushing on a button, then here again, it's probably very likely that this wouldn't be accepted as a work of art by most of the legal systems we have queried. However, some legal systems have decided to introduce rules in their legal system in order to address this. And we see that the UK is one of these countries, and UK adopted back in 1987 a new fiction in its copyright law in order to address computer-generated works. So this is a presumption of authorship that is completely created by the law that says that whenever a computer-generated work is created, there is one person who will be deemed the author, and that's the person by whom the arrangements necessary for the creation of the work are undertaken. Here we see that even a very limited input can be overcome by this definition. However, you continue to see the need for a human person to be included. And you continue to have a problem if you have absolutely no human creation, no human input, and no one that you can tag as an arranger of that particular content. And then finally, there are some bigger questions that are being asked by this new possibility offered by AI-generated work. So this idea that machines are now capable of creating work of art is really challenging the essence of copyright. In a lot of legal traditions, including in the common law tradition, copyright is seen as an incentive. However, today, the same legal systems are asking whether machines need to be incentivized and whether machines need some financial reward for their work. There is logically this impression that whether you give copyright to a machine or not, it will continue to generate content. If you go to the civil law systems, including France or Belgium, for example, there is a tradition that copyright is a natural right, that copyright is almost a sort of a fundamental right that is given to humans as creators. But here again, protecting AI-generated works on the basis of natural rights seems completely unreasonable. And there is no individuality in an AI system that would merit that you attribute to it the fatherhood, what we call the paternity of a work of art. And of course, the fundamental question, which is the same, whether you look at common law system or civil law system, is whether we should give some value to copyright works created by machine or to works created by machines, or whether a copyright should not be only limited and only afforded to humans, because human creativity should be valued over machine creativity and should be rewarded and compensated and not diluted. Because, of course, there is also an element of a human taking time to create a work and a machine being able to create a gigantic number of works in a fraction of seconds. And thereby, some would argue that there is a risk of dilution of the human creation and the risk of the economics being completely reshuffled under the influence of copyright, if copyright was accepted as being as existing in a machine creation. I think that's all I have time for, and I think I was reaching the end anyhow. I don't know if you have any questions or comments or observations, but now is a great time to ask them.
Yeah, thank you, Sophie, so much for your keynote, especially taking into account all the different copyright laws all over the world. It's pretty tough, really. We have two questions from the audience. One is by Mark Simos from the US, who was asking whether similar issues arose earlier in earlier innovations, such as in algorithmic compositions too, like without machine learning, just rule-based systems. Were there also the same concerns?
Maybe. I'm not aware of any decision or case law that would have looked at that, but I would say probably. I guess the difference between what might have happened then and what's happening today is just scale. The fact that AI is becoming such a huge topic and is basically becoming so big these days means that there is an interest from legislators around the world which didn't exist before.
Then, thank you. There was another question from Cornel van den Broek from the Netherlands, supposedly. He was asking why you were talking about the copyright exception for temporary acts of reproduction. without AI, was that like it existed before AI? Could you give an example why, like on which occasions was that necessary?
Yeah, so the exception was invented mainly to cover cache copies. So the copies that are necessary to, for example, for streaming in your browser, but also some of the cache copies that can be made in a decoder box. So that was the primary reasons why this invention was created at the time.
Okay, great. Yeah, then I had another question. Like the Article 17 of the new copyright directive from in the EU, provides that that online content sharing service providers need to obtain an authorization from rights holders for the content uploaded on their website. Could you give us an insight on which what the impact will be, maybe for tech startups? In connection with this Directive 17.
That's a 1 hour response probably, but I'll. It depends of the tech startup, I would say. I mean, if the tech startup is creating a service which could qualify as an OCSSP, so an online content sharing service provider, then of course there will be an impact which will be quite significant for that startup. So it really depends on the business model that you are adopting. I guess if I can make some general comments about Article 17, yes, it will have a significant impact on the tech landscape for sure. We are still in, it's early days. Some of you may know there is still a lot of uncertainty about how this Article 17 is going to be transposed. There is actually a legal challenge pending, there's been a decision. We're expecting a decision of the CGU on whether or not the legal challenge that has been raised by Poland will result in some of Article 17 being amended, being annulled, or if it's going to be upheld. You have guidance that has been published by the European Commission, which is sometimes aligned, sometimes absolutely not aligned with how Article 17 has been transposed. So as of today, it's really difficult as a lawyer to give a definitive answer about this is how it's going to happen and this is what is going to happen. But I think if the question is it going to have an impact? The response is definitely yes. And probably on the whole sector, the music sector, the tech sector, and the online sector at large.
Mm-hmm. Yeah, I can imagine. Thank you. We have another question by Thomas Nilen from Spain. He asked if a creator is using an AI-powered tool and that tool in turn is trained on copyright-protected data. Is the responsibility on the user or on the creator of this tool?
So if I understand the question correctly, you would basically give me access to a tool and I can choose to train that tool the way I want, and I will basically decide myself as a user which training data I want to use. So if that's the understanding is correct, then of course you probably would have to take me, the user, by the hand and give me some guidance about what I can and cannot do, and what are the different rules I would need to observe when I decide which data to train on. That might mean that you will give different guidance to a user which is in the US, a user which is in the EU, or a user which is in Japan, because the guidance you will have to give to the users will depend on the legal system that is applicable to them. But I guess that it is probably a really good idea, if you are going to put this type of tool on the market, to have at minimum an FAQ to help the users of the tool understand what are their responsibilities and liabilities and how they can use the tool in a way that is compliant, and that they do not inadvertently end up infringing on copyright without being well informed about it.
Okay, so if I use the tool and I didn't know that maybe they violated copyright laws, and I will use this tool, like, is there a problem, like, for me as a user, or will the company, like the creator of this tool, be?
Well, it probably depends. So, for example, it depends if you, as a user, you will decide where to go get the music. So if you are in the EU, if you get music from your personal library and you use it as a training set, then you have to check whether this exception applies or not. And how do you check whether the exception applies or not would be, how can you try and understand or check whether an opt-out has been exercised or not. So that's a bit of a complicated maybe checking mechanism that might need to be looked into or considered. But then if you are talking to a user in Singapore, where I believe that there is a copyright exception, which is quite broad, then potentially you could offer to that person in Singapore a different guidance, and maybe provided that the source of the copyright material they use is legal. So of course they cannot go and get illegal recordings out there, but provided that they have access to a legitimate source of copyright material, it could be that in relation to the users that are in a legal system where this exception is quite broad, you could tell them that they have a bit more flexibility in using the tool than the users that are in a country where the same flexibility is not as broad. Okay, I don't know if that makes sense, but it really depends on whether you, like, if the creator of the tool already gives access to the data. So if there is a choice, for example, a menu within the tool to choose the data, then of course, then the creator of the tool would be responsible for that. If you give the tool without any data and then you leave it to the user to choose which data to put in the tool, you also have to be careful that you are not going to be considered as facilitating infringement, which is why it's really important to give a methodology to the users as to how they may use the tool in a legitimate way.
Okay. Yeah, then...
I hope that makes sense.
Yeah, totally. Thank you. Thank you so much for your keynote, for your time. We really appreciate it. And yeah, we'll hopefully see you next year and have a nice day. And for the other participants of the AI and Creation Day, we'll see you in the next session.